So good afternoon. I know we have like a busy afternoon schedule, so we'll try to give as many breaks as possible. And we'll try to keep, that's why I said, so we have like 4 different teachers going to do this afternoon with you so that it doesn't become entirely monotonous. But the reason we did all of those presentations also was to see where the class was and to see how much we were able to um, speak to your own concerns and how much of what we have done so far is resonating with all of you. We were also just checking to see if what we were saying is making any sense to you. But so one thing, anybody who wants a course completion certificate has to do the assignment. If you're not interested in the certificate, there's no issue. But if you are, then you will have to do an assignment. So if anybody who has not thought of an assignment should either be part of some other group or think of an assignment for yourself. Okay. So that's clear, right? Any other questions coming up from? Did you make a presentation on? No, what happened? You're not there?
I wasn't there. I wasn't feeling great, so I didn't come.
Okay, so those of you who have not yet made a pitch, I think there are a couple of students, like Nalsa students also, 2-3 students have not yet made any pitch about what you want to do. So you might want to think about it. We are saying that these sessions that we are doing specifically today, the 4 sessions that we are doing today, we have kind of reoriented it to be useful to you. So whatever we want to say on constitutional law or on criminal law or on recording of that, on constitutional law or criminal law, we are going to tailor it to what we have heard in the morning from all of you, right? About what kind of issues you want to work on and in what way we may provide the required resources. So please remember, what you told us is just like a germ of an idea. You will need to flesh it out, and we will need you to be able to explain why that is important to you, whatever concept you have taken. So you will need to explain why that is important to you, and you will also need to explain do this. Yes. So you also need to explain why this is important to all of you. What is it that you're doing? And anything that we have said to you, in what way does it resonate with you? Right? So you are at stage 1, which is what is the idea that you have. The second step is what kind of reading or what kind of references from the materials given to you is going to be something that you are using in your assignment. Okay, so I will need to see an engagement with the materials, with the kind of ideas, with what is it that we have been doing with you, come through in your presentation as you're fleshing it out. Okay, so for example, some of you have taken up this whole business of where does dignity fit in, let us say, what are not called modern cultures, right? Or what are pre-modern ideas, or what are the ideas coming from religion. So when you want to engage with that, we have not touched upon the issue of religion, right? We have not, though we know that there is an entire area, body of law that is emanating from religion, from culture, we have not actually addressed it in our lectures. So then the question is, what are these ideas that you will then be able to map to this whole business of what is coming from a religious law, right? And all of you know our fundamental norm in the Indian Constitution. There's a big question mark. The Supreme Court itself is not clear about whether personal law is law, right? So in that context, does the Constitution or any value coming from the Constitution like dignity have any relevance for an idea that is coming from before, right? And some of you have spoken about it in your presentations as well, that the idea of dignity itself has evolved from an initial idea of dignity of certain person to dignity of all. And it is very questionable as to whether all religions are coming from this starting point or have they evolved towards this starting in the way in which they were originally formulated and in the way in which they are moving. So are you open to the idea that religion is evolving? That religion is not static at any given point of time, that a particular religious text does not reflect the position of religion today, because religion itself is evolving, religion is not staying static at any point. So these are questions, especially if you want to take up something of that magnitude, then there's a whole level of reading that you will have to do before you're able to open up that project to see. You cannot, so there is this fundamental thing that you can't compare apples and oranges. Right? So anything that's emanating from a modern democratic text, like the Indian Constitution, to something that's coming from a very different place, how can you even match those two? Right? And what are the places that you are thinking that they are coming together? What are the places that are not coming together that you can't really talk about these two things in the same breath? So this whole business of secular law staying away from religious law, right? Because they're coming from two very different places. So how do they coexist? Is one of the most complex questions of our time. It's not a simple, straightforward, yes, no question at all. It's an extremely complex question. So when you want to engage with such a complex question, what are the tools you are going to use? Become very important. Okay, so there's the idea. There is a set of reading that we have done with you that you should be able to say, how does it connect with what you're doing? And the third part is, what are you going to do with it, right? So we said that in terms of a strategy, because we said that this is a clinic, so we want all of you to look at a strategy. And this strategy is aimed very clearly, since it is a dignity rights clinic, it is aimed to amplify dignity, not anything else. Now, any of you who've read the Bachchan Singh judgment, do all of you know this particular decision of the Indian Supreme Court? What is it? Bachchan Singh versus Punjab, or what is it?
Imposition of reform.
With Bachchan Singh versus Punjab? Imposition of death penalty. Okay. Do all of you know what is the most famous opinion in that case, or whose is the opinion is often referred to? Is it the majority opinion? Is it dissent?
Dissent opinion is, I think it's by P.N. Bhagwati.
So what is P.N. Bhagwati going on about? Do you have any recollection? I have an extract that I want to read out to all of you. I was just setting context. Do you remember what is it that P.N. Bhagwati is doing in this particular case?
What I can recollect, like the majority judgment, they obviously upheld the constitutionality of the death penalty and they came up with the rarest of the rare doctrine. P.N. Bhagwati had a strong dissent, and I think he also first he talked about the arbitrariness of the death penalty itself,
Yes,
and
yes.
I think parts of it were also concerned with how it also depends on the politics of one judge to the other, so it depends on that as well. And I'm not sure if this was part of the judgment, but like the latest research also shows that there is like a social angle to it in the sense that the most marginalized would end up getting the death penalty.
Right.
I'm not sure if this was addressed by him, but this is also something which has come up in the literature.
Right. So he has this whole business about arbitrariness. Is there a dignity angle to what he's saying? Do you remember? There's a dignity angle. So that's what I'm asking all of you to look at. This is all material you're familiar with. I'm asking you to search to look for where is the dignity argument figuring. Why is the dignity argument required? I think what Professor Delhi has said from the beginning, there are many issues where you can make a very strong argument without relying on dignity. It is not required that you use dignity in all arguments. Those of you who were at the conference, that the one thing that really stayed with me was that dignity is often referred to as the Swiss knife, but it is not a Swiss knife. All of you know Swiss knife is supposed to be this small thing that has multiple blades. You have like 3 or 4 blades, and it's multi-purpose thing. The idea of persuasive is multi-purpose. That a lot of people refer to dignity as this multi-purpose thing, but she's saying that no, it is meant to take out the hardest part of case. So even if you're looking at Puttaswamy, entire privacy jurisprudence is resting on dignity. So dignity is a core which doesn't automatically or necessarily get invoked at everything. And that's what Professor Peetham is referring to as dignity inflation. That you really don't need to make everything a dignity. It's not required. There are like 300 other tools that you can use to address that question. The question is, when does dignity become the only way in which you cannot find an answer to it? There is no other answer except dignity. What is that hard nut to crack for which you require a special tool? And so dignity becomes that very core, that this can't be violated. The minute you say this, which means you've crossed an entire range of things to come to that core. In that sense, it's your, at one level, it's your basic humanness, which is what we are invoking when we invoke the idea of dignity. And so I thought Bachchan Singh was a very good case. Because if you're talking about death penalty, it's very easy for judiciary to say that, yeah, reasonable classification. Of course, this is legislative job. This is not our job. We don't need to do this. We are not deciding for legislature. Legislature can decide this. If the legislature says death penalty, we will give death penalty. Legislature says no death penalty, we won't do it. It's not a question for us to engage with at all, because it's not a question that is bothering us, that is troubling us. So when does it become something that does not let you sleep? That is the dignity question. What is it that says that I have to answer this question and I'm not able to answer it in any other way? That's where dignity has been invoked as one of the most powerful ideas of our times. Not for, I mean, I'm not at any point saying equality or liberty or freedom, religious freedoms, all other freedoms are not important. Of course, we can't live without all of those. But is there something without which you cannot, that your existence is meaningless? That there is nothing that makes you human if that is not there, right? And that is what we are trying to get at in all of the issues that you are looking at. You will really need to go deep and say, okay, why is this a dignity issue? Why is this not, let's say, a discrimination, inequality issue, arbitrariness issue, or whether direct or indirect discrimination, or liberty, or freedom, or 100 different things. Why is it not that? Why is it a dignity question? What is the raw nerve that you're trying to touch upon that makes it so important for you to say, no, this is a dignity question? It's not, it's all of this, but it is also this, and that's why we are trying to look at it. So if I'm looking at, what Bhagwati says in the context of, where does religion play a role? We have been looking at dignity both as a moral and a legal question, right? We are not saying this is only a moral question. And we all understand that when we kind of venture as lawyers, when we venture into the moral question, we're actually on very, very shaky grounds. That's not our forte. We really don't know. There are 300 things there, and we really don't know what to do with it. So we are saying that, okay, where does it become, what is the legal question here, but which has a core moral question that has to be answered? So while we want to insist that dignity is a legal concept, it's not just a moral concept. But we're also acknowledging that there is a certain dimension to it. And why are we saying this? We're not saying whether it's desirable, undesirable, required, not required. We are going by empirical evidence. What is the empirical we have as lawyers? Our empirical is what courts are saying, right? Because when somebody is asked to justify their position, they can use any language they want. There is no compulsion on them to use X, Y, Z. Why is it that they want to invoke it? That's our curiosity. And that's That's the material we are working with. We are not justifying whether this is good, bad, they should do it, they should not do it, but they have done it repeatedly, which is what we are trying to point your attention to. So if you're looking at what Justice Bhagwati says in the Bachchan Singh case, and this is where the moral and the religious question kind of become entwined, and as I was reading this, I thought maybe I should read it out to you in class to see how is it that while deciding questions of core criminal law, we are borrowing from or we are basing ourselves on these moral ideas. And look at his sources. Okay, this is just, I'm not justifying it, we're not doing anything, I'm merely asking you to look at what he's saying because this is something a judge is saying while he's answering a question. This is where he's coming from. So all of us understand judicial decisions as public reasoning. We are trying to put out a judge is trying to explain to the larger public why he or she wants to decide that. So this is a paragraph I thought I'll read out to all of you and look at his sources, right? Mine is unfortunately a solitary dissent, and it is therefore with a certain amount of hesitation that I speak, but my initial diffidence is overcome by my deep and abiding faith in the dignity of man and worth of the human person. And he doesn't stop there, and passionate conviction about the true spiritual nature and dimension of man. And so at one level, you are acknowledging that human beings, while being rational, that's the question we also raised, right? Law is rationality, 90%. But somewhere, if it doesn't have that element of morality or spirituality, it becomes very dry and people don't really associate with it. At some level, there needs to be a certain level of, whether you want to call it passion, whether you want to call it spirituality, whether you want to call it morality, you can have different questions. But that is the core, and dignity at that level is not just a right, it's not just the legal, it is also speaking to that particular aspect in many ways. So he goes on to say that the worth of the human person and passionate conviction about the true spiritual nature and dimension of man. And then he goes to Bernard Shaw. I agree with Bernard Shaw that criminals do not die with the hands of the law, they die with the hands of other men. Assassination on the scaffold is the worst form of assassination because there it is invested with the approval of society. Murder and capital punishment are not opposites that cancel one another, but similars that breed their kind. Then he moves to Gandhi. It was the father of the nation who said years ago, reaffirming what Prince Satyavan said on capital punishment in Shanti Parva of Mahabharata. That destruction of individuals can never be a virtuous act, and this sentiment has been echoed by many eminent men such as Leonardo da Vinci, George Bright, Victor Hugo. I'm not trying to be judgmental about what he's saying. I'm merely pointing out to you when and what is it that you're borrowing from religion becomes very important. And the why, of course. Why do you think it's not enough for you to say constitutional law, for you to say equality, for you to say freedom and liberty? Why are you searching for something else to justify all of this existence? And look at the way in which our courts are struggling to find justification in what one might term a larger social context, societal context in which law must make sense. If it doesn't speak to that, then law just becomes a dry set of rules and regulations and, a statute and whatever. So that is the core that somewhere, at least if you're looking at Bachchan Singh as one authority, that they're trying to source their dissent from an understanding of human nature, from an understanding of society, and a vision of what kind of a society we want to live in. Believing that this has a repercussion to the kind of society we want to live in. Why are we saying that dignity is important? Not because it is observed in everyday life. No, that's not the argument we are making. We're saying that we want to live in a society where dignity matters. And we believe that if we try to make a society in which dignity matters, it is a better society for all of us to live in. So that connect between a moral idea and to make it something that all of us would want to live in. It's a society that we all want to live in, which will be equally useful for everyone, which is not privileging one over the other. That's the idea of equality of dignity, right? That everybody is equally dignified. You cannot create hierarchies. There are no hierarchies in dignity. Everybody is entitled to that basic idea that we're all equally entitled to dignity. Okay, so this is one instance of what we are saying. So here you have an idea that he was talking about death penalty. He's sourcing it from all of these various sources. And of course, he has a privilege of giving a dissenting opinion. He gives a dissenting opinion, but then you guys need to figure out what are you going to do with all of this.
So I'm just trying to figure out like what his idea of dignity could be from the paragraph also that you were reading out. So like, do you think that perhaps you could say that he is seeing dignity as valuing the sanctity of life, like all life? And if we see dignity as that, like dignity can't just be that, but if we see that as sort of like an element of what dignity is as a broader idea, then almost the same language it can be and is used to protest against euthanasia, right? So I was just thinking about that when you were reading the lines as well.
Yeah, this whole business of the inherent value of human life, not necessarily what are you going to do with it. That's the tricky part, right? Do you believe in the sanctity of life for the sake of sanctity of life, that life itself, that heartbeat, that whole business is not just euthanasia, right? We were talking about the whole abortion question, that there's a heartbeat and so you can't take a decision to then end life at that point of time. So that whole question of is life, and that is and for me, that's why I'm in first classes, it's a contradiction. If you say there is intrinsic value, because there's intrinsic value, then how do you then talk about this whole business of consent and autonomy and free living and and if you don't see it as a contradiction, how are you exactly lining up that set of things to say that there is no contradiction? To my mind, it's not very clear in my mind how exactly one resolves that. And at this point, I'm merely saying that there is a question when you say intrinsic worth of human. Then of course you can be very technical lawyer and say no, that person is not human until born. But that's not really an answer to satisfy you. It's not an answer to satisfy you. You have to look for something else. The technical answers are there, but this kind of an answer is, I think, still very difficult to come to. Yeah.
Maybe one space where we can draw the distinction, especially in cases of euthanasia, passive and active, is the
passive and active are not the same.
Oh yeah, I'm just meaning that. I just mean that there's some sort of commonality.
No, that's what I'm saying. Between passive and active, there are people who are coming from sanctity of life to say that what are you saying, that you allow me to die slowly by starving me is somehow better than giving me a little injection.
Yeah, so what I was trying to say was to talk about the parallel that was drawn between death penalty and also euthanasia. Is that the key factor, I think, is about choice. And with euthanasia and with death penalty, it becomes very stark that dignity is not just about life as is, but also life as it is led.
Right, so that's a contradiction, right? Either we're saying it's inherent, intrinsic, then the question of choice is not the relevant concept.
But that's like, I think the intrinsic part is a bare minimum that you afford. And then the choice is how you, it's not just at the level of intrinsicness, right? Because in that sense, then you completely denude dignity of its social context. Because socialization doesn't take place right at birth, right? It takes throughout your life.
Yeah.
So there, then choice becomes important, and that's why euthanasia can still be dignified and have a dignity aspect to it. Is what I was trying to.
Yeah, and I'm not disagreeing with you that euthanasia doesn't have a dignity aspect. But what is the justification? Is it consent or is it intrinsic value? When courts kind of go on and try to decide on whether or not people should be allowed to end their life in situations where they have not consented. The consent is an easy question. I have made out my living will, fine, we'll put all of those into one basket. What happens to cases where you have not made any living will? Your next of kin has to decide whether you're going to live or die. And the court has to decide whether they should let you live or die. Then what is it that we are going to value? Are we going to say there is intrinsic worth of human life which needs to be preserved at all costs because that person has not consented? Or are you going to imply consent and say, no, it's not intrinsic worth at all. It is about whether that person would have wanted to continue to live like that. And we have evidence to prove that he might not want to have consented to live like that. And hence we think it's okay for the next of kin to pull the plug.
My perspective was just, and this is something that we've done throughout constitutional law, that you're not supposed to balance rights.
Right. Correct.
So that's why I was saying that.
Correct. So if you had to decide on pulling the plug when the person has not actively given consent, you would have to decide on one of these, right? Unfortunately, this is not one of the situations where you can do both. Or can you?
I mean, I think it's a way to reconcile it because, and that might be from a biased understanding of what life is, but life is not just life, but the basket of threads that we've talked about. And when you're talking about passive euthanasia, that person is completely devoid of all those rights. So I suppose that sort of reconciles it for me. But it could depend from judge to judge.
It could depend, right? So this is where I'm saying that those of us who are able to see that there is no contradiction, we are able to line these up and say, yes, it is intrinsic and it is consent, and it's only when all of these are like, and that could apply. So it is a question of taking a position. I hope I'm trying to getting all of you to say that you will have to take a position for yourself. Are you saying that's just intrinsic worth without anything else? For example, if you read what Bhagavati is saying, is he saying anything else about other than intrinsic worth? The death penalty case for him, isn't it just intrinsic worth of human life? Or any of you who've looked at it can find anything else here? Because he's saying that there's no distinction between murder and capital punishment. Why is there no difference? It's only when you say there's intrinsic worth that there's no difference. At the end of it, both of you, in both cases, you're just exterminating life. So there's no difference between the two. Right? All of us could possibly say, I don't think the two are the same. Right? So when I want to line all of these up, and what seems to be the value by which you're lining all of these up? In this case, it seems to be the intrinsic worth by itself, by saying that no, death penalty as well as any other act of violating life would be the same because both of them are violating intrinsic worth. So I'm just pointing out to you two things. One, when courts get into the moral ground, look at the variety of sources. What, Bernard Shaw to Gandhi and to Gandhi's religious justifications that are being offered in this case to stay. And all of these, in essence, are only speaking to intrinsic worth. This is not a case where we are saying there's anything else of autonomy or consent or worth living or anything. We simply think a person should continue to stay in prison for the rest of their lives because we think that there is something intrinsic that is worth preserving, even if he himself would possibly say that this is worse than death. Right? So this is where other people and all of us take decisions on what are the ideas that are motivating us to take particular positions. And since we did so he goes on to say, he's quoting Bernard Shaw from Cleopatra House. And I don't know, what do we do with these? How does Cleopatra become a justification for? Really? I don't know. So anyway, and then of course he gets into this, I share this sentiment because I regard men as an embodiment of divinity. And I'm therefore morally against death penalty. But interestingly, then he says, but my dissent is based not upon the ground of morality or ethics, but it is founded on constitutional issues. For, as I shall presently show, death penalty does not serve any social purpose. or does not advance any constitutional value and hence is entirely arbitrary and unreasonable and hence violative of 14, 19, 21. So he comes to the legal argument, but somehow the legal argument by itself is not enough for him to justify to himself why he is taking this position. So the thing about judgments, and at least the way I read judgments, I'm not at all interested in what they do finally with it. I'm just looking at their pangs, no? I'm looking at that process of how do you come to a decision, at least for those judges who are honest enough to try and expose themselves to this scrutiny, not hide behind 300 kinds of copy paste and then say, somewhere in all of that, I have given you my reason, you figure out what was my reason. At least there are judges, and what are the opinions worth reading are opinions where you find the judges engaging with a important question, which is what we want all of you to emulate as you're going ahead to say, okay, why is this a dignity question for me? Why would you want to justify it? How would you want to justify it on these grounds? So then he gets into the whole legal argument of 14, 19, 21. What I also wanted to do with you is, since inevitably it becomes either a reproductive rights question or a Dinesha question, is to look at the Suchita Srivastava case. Have all of you ever heard about this case? What is Suchita Srivastava?
Reproductive rights.
Okay. And
So that wanted to carry on with the pregnancy, but
Right.
the family members petition
Right.
mental health issues
Right.
and she did not be treated.
Right.
Child, but the court said ultimately depended upon her choice, her
Right.
bodily choices and autonomy. So
right.
if she thinks she's capable, she should be allowed to continue with her pregnancy.
Right. So this is a case of a woman who was in an institution. So she was in an institution for persons with mental retardation. And so then the question of capacity becomes important. Unlike other women who are deemed to have a capacity to take a choice, the question is, does she have a capacity? And the question is her capacity to be assessed on the basis of her own dependency? That she herself was in an institution, living off state funds, so to say. And then is she in a position to then make a choice? So there was here, more than the intrinsic worth, the choice question was very central. As is she a person? This is as much about the unborn child as about the woman who has to take a decision. Is she in a position? Can she claim dignity rights by saying that even if I am in an institution, and even if I am under the so-called protection of the state cannot decide for me whether or not I can carry the child. And even if I'm a person deemed to be retarded by the law and hence in an institution, do we still say that a question of choice becomes relevant? And so Suchita Srivastava becomes an important case to look at the question of dignity from persons who are not deemed to be able to make a choice, who are not deemed to be able to consent. So here the court goes into the crucial consideration is that a woman's right to privacy, dignity, bodily integrity should be respected. However, in the case of pregnant women, there is also compelling state interest. So this again becomes a balancing question as against the idea of dignity that you saw in Bhagwati's opinion, where there is not even the need to punish for serious or heinous crimes. It's a compelling state interest. Right? In fact, it says the distinction between death penalty and other forms of penalties are arbitrary, unreasonable. Who do you pick and choose? So he's not talking about compelling state interest there. But suddenly in this case, the court is saying that there is compelling state interest. So this is where possibly the inherent idea is playing out. Saying that the fetus's inherent right or the intrinsic right of the fetus also, even though technically they are not the human person yet before they're born. So though legal sanction is not there. But this is where the moral idea of that right to live is recognized as a dignity question, and hence you will need to balance out her right against that right. And so there's a compelling state interest in protecting the life of the prospective child. Therefore, termination is permitted only in a prohibited manner. So there you have the whole proportionality question, the balancing question about this and that, and we have yet not recognized a complete right of the woman to choose. Even as we are using a dignity framework, we are not saying that she has the right to choose whether or not at that point of time. So while it is a case on choice, it is a case on a choice of a woman to continue or not continue her pregnancy, but then that choice is mediated by state interest to say that, okay, yes, there is choice, but there is also this compelling state interest which has to be taken into account. So even though this is a dignity question, it's not answered in that very unequivocal manner that one would want to expect. At least to my mind, it says that the whole business of choice, consent and all, while the justification and a base for dignity is not as morally compelling as the intrinsic argument is.
In my opinion, the state says that there is this conflicted interest and you are considering the intrinsic value of life of the fetus.
Yeah.
I think what the court does not take into consideration is what happens to the child after it is born.
Absolutely.
Because, for example, in another case that I had read, X versus Union of India in 2023, here the mother was like, she already had children.
Yeah.
And they were a joint
This
family.
is a postpartum case. There was one more case where she was suffering from.
Yeah. So the husband could only support that entire joint family.
Yeah.
The only earning member.
Yeah.
So the mother was not only mentally ready to carry on another pregnancy,
Yeah.
they were also not financially ready. But then the Supreme Court said that the pregnancy should go on because of the medical board's opinion, and said that we are, once you give birth, if you want, we can allow it for adoption. So my question is then, how are you respecting the dignity of the child? You're bringing it to, like, you are allowing for its birth in a family that does not want it, and then you are allowing it for adoption.
Yeah.
So then being treated with dignity, you're not allowing the mother to be treated with dignity, not even the child.
Yeah. But if you go with this very basic idea of intrinsic value, nothing else. Life is life for its own sake. That's the only justification. Which is why whether that's the solid enough ground is the question. That's the only explanation I can think of as to why would the court do this. Coming or continuing from Bhagavati, it is just intrinsically there is life that is worth preserving. Irrespective of what is going to happen to her and to the child, the consequential aspects are not really something that are going to determine it. It is that idea of intrinsic worth of life. That's still a very compelling idea, which kind of resurfaces even though we have other things. Which is why, to my mind, it's not a very settled question of what is the basis for dignity. Are we saying that it is going by these kinds of cases that we're looking at? Is the court really privileging intrinsic value more than questions of autonomy or consent or any other aspect of choice, or any what is known as a rational, reasonable question, rather than just when we are happy to just let the child be born. Uske baad, whatever not our concern, because our duty is done. So they feel their conscience is satisfied by allowing the child to be born.
Argument would be that it is the judge who has the discretion to prioritize
Absolutely.
which aspect is more important. If he's considering the birth of the child to be more important than its raising.
Right. So what we're also asking is why. We're able to see it that they are doing this, but what could be the reason why they are doing this? And possibly one explanation is this really compelling idea of intrinsic worth and value of human right. So two cases, and then let's look at Arna Shanbag before I hand it over to Professor Daly to look at the question of the rights of the child, because we haven't really spent much time on that. Now, on the other hand, if you're looking at the entire gender identity question, then that's so clearly a question of autonomy and choice, consent and freedom. Then the question really is not of any idea of an intrinsic dignity, freedom, democracy. These are words that you're seeing when you're looking at the Nalsa decision. So when you look at Aruna Shalbag, which is the other case on the death penalty that we all are familiar with, and the common cause case which comes after that about what kind of procedures. So when we're also saying even in our own organization, at the end of the day, we will have to talk about procedure as lawyers. And how does that procedure emanate from an idea of dignity, or it does not emanate from an idea of dignity? Now, those of you who are familiar with the common cause case, and the second one, that is after the first Aruna Shalbag, you had the common cause case which talked about the procedure by which these decisions will be taken. Yeah, any familiarity with the common cause kind of guidelines? What guidelines were given by the court about, in a way, the bureaucratization of dignity law? By saying that you will need boards to be set up, you will need district level officers, where the living wills will need to be registered. And unless all of that is done, then the question of, allowing people to terminate their own lives is not going to be allowed. Right? So while this is the moral idea that is being translated, when you see this translation into procedure, which needs to be followed with reference to registration of the wills, with reference to the kind of authorities who need to be set up, and how sensitive are these authorities to the ideas of dignity? Or are they just looking at it as just some filing that needs to be filed to say, all right, we've got this file, we have it on record, so now you can refuse treatment or you can't refuse treatment. Everything then becomes about the procedure that has been set out by the court. And at that point, have we somewhere lost the plot? Have we lost the idea of what this is all about? And how does law not lose the plot like that? That is our question. So from where we started off to the kind of procedures that we end up with, and how those procedures need to be looked at when one is talking about these questions, is something that entire stages in which the idea evolved is something that we wanted to introduce all of you to, in terms of what is the idea of dignity as evidenced by a few cases from the Indian Supreme Court. This is not an exhaustive survey of cases. This is just a set of cases which have spoken about this question, which have been very compelling and which have been very, what should I say, influential in the way in which the jurisprudence around dignity has kind of progressed. Been very important cases, very important landmarks. Before, of course, the Puttaswamy case, then locates all of privacy rights into dignity rights, and saying that since dignity is recognized in the Constitution, privacy is also recognized, and since dignity and privacy are recognized, a whole range of rights are flowing from. That's the seed from which all of this is then emanating. Okay. Any questions that you may have on how does the Indian Constitution speak to the question of dignity? The materials we have given you, actually, there are two readings, right? One is by Professor Bakshi, who's taking a completely, so when we do this whole morality, intrinsic worth, he has a very different dimension to the question of rights as well as dignity. When he's saying, how does the question of pain or suffering then figure in the idea of dignity? It's a very different interpretation of what we mean by rights, and why should courts take up this question not just as a legal dry question of, procedure or protocol, but how courts need to take it up to ensure that suffering ends. And he's rooting the entire jurisprudence on dignity in terms of the suffering of the human person, and how should that suffering be understood by courts, not only as a question of right. So even where we started off, when we said dignity at a particular level stands outside of the law, motivating the law, pushing the law in a particular direction, but it's not only about a right. So at that level, when you take off the layers, what you reach is where we are saying that dignity is a very human idea, and when we want to extend it to, let's say, all sentient beings or rights of nature, what we're trying to get to it is that core. of pain or suffering or feeling or emotion. And you can't understand this as a very rational idea only emanating from, in ideas of reason and ideas of right and wrong, only in a legalistic sense, but at a deep sense of the idea of justice of what is correct and what is wrong. So that's where dignity then you are able to move into other areas with, let's say, climate change or ideas of, whether other beings are also capable of feeling and emotion and pain and suffering. So Bakshi gives you a very interesting and obviously a very, very different idea of how does one understand this whole business of dignity. And then the other reading we have told you is about the inconsistency in the Indian Supreme Court on how it has articulated the right to dignity, whereby saying that perhaps we need to rethink how the court is looking at justifications for dignity. Any questions on any of those? If you have looked at it at any point of time, or if you have any questions.